I had this story that I heard, and I can't remember where I heard it, so I'm a little bit nervous to share it because I don't know if I'm violating podcast privilege here, but I'll go ahead and share it anyway. I heard a story from an attorney who was mediating, or involved in mediation of a case pending appeal, and there was a retired judge or justice who was doing the mediation, and the settlement discussions were stalemated. And the mediator came in and said, well, it just so happens that I talked to my good friend, Justice so-and-so, who happens to be on the panel with a draft opinion in your case. Now, of course, I can't show it to you, but, oh, excuse me one moment. I have a phone call. I'll take this outside, and leaves the printout on the table there. The attorney and the client look at each other. Should we, shouldn't we? Of course we should. They take a peek. They see the writing on the wall. Lo and behold, that afternoon, the case settled. Now, does that go back to Judge Wallace's VHAF ways to get people to talk?
I'm not sure whether Judge Wallace thought of that particular method. It might indeed be a fairly effective one, but I think that might be a somewhat unique occurrence. Of course, when the Ninth Circuit started their program, that was back in the days when the average time from the filing of the notice of appeal to the decision coming out was kind of well over 2 years. They were terribly, terribly backlogged at one point. And so I think one of the reasons why they were so proactive in developing their program was that they felt they just needed to do something about this case backlog. These days, although most of my work is in state court, but the last time I was in the Ninth Circuit not too long ago, it seemed to go fairly quickly, the whole thing. But nonetheless, they still have their program.